Right, we still have not heard back from the bankruptcy person's lawyer.
Well, I think, right, look, that was their offer, right?
I set the motion, I
So
said,
what we can do is what we've proposed here, and if
yeah,
it plays out fine. If not, we have to have another meeting and we'll do that.
just haven't heard anything.
I know.
Michael Medina, and to have this be over, because when you look at the polls, it is incredibly unpopular, even as he makes the case for Iran not having.
Anyway,
We would. The power one is not used, I don't like going.
The first day was, the first couple of days were really nice. And then. Greg.
He's muted. I muted him before I left. Log him in and mute.
I hear you do that fairly often.
No.
Doris, do we know you? I'm Roger.
I'm Jen.
Yeah, that's Jen.
I met you.
I'm just saying to his mother. And she's
Look great.
Jen had glasses on. So she looked at Jen and said, Doris. I'll work at
You're doing a good job. Whatever you do, maybe I need it.
Requires an officer. I just need you to practice your signature. That vote, really?
The opening card's small. Yeah, I like that one.
Gotta keep moving. Come back. Walk for an hour.
Yeah. $25 for Hillary. Yeah, $25.
The Catholic, she goes, you want to do the Costa Bella run? I go, okay. I didn't know what that meant. I've never. Yeah. Yeah.
This.
I go,
This.
oh, I know what you mean. I said, you don't know what you're.
To keep it modern, yeah, that's my jacket. But he was here.
Right. I know.
Yeah, it's prohibited. And they keep adding, I'll go bring it a girl. She go, how about this? I got it. How about this? I got it. Oh,
I know.
She, let me show you the one I don't have. That one right there.
When I.
And I've gone from what color and never. So if you go, your one,
I have them.
like the little label, and then your shirts, you do the,
Yeah.
you do the slim fits? Yeah, so that's a green label. Your other one is slim fit, and then there's the medium fit. And then, which I never wear, but I've gone to the medium now. There's slim fits, don't fit arms, they don't fit arms. I can. And then you just have tailoring. Yeah.
It's something.
My granddaughter.
Oh, he's got to get a stamp.
Well, he wants to get. But he's. Sorry to get it. So that's why I have it.
Great.
Well, I bought Venus first. That's why I mean,
Yeah, pretty good. It's gonna be warm in here.
by the time I saw her person.
Who's already got the call? Wow. I'm such a crossbody person. I feel like
Email.
I wear mine in the house. Like I wear it. I just wear it. I use both my hands.
Anything else?
Yeah, I have. I feel like I have another.
What's going on, Mark?
My.
All good, Michael, yourself? Peachy.
I have my. But it's a little.
Hope there's enough room up there for Richard.
Well.
Otherwise.
Oh, my God. Oh, my God.
How do you feel today?
Yeah, it's,
Oh, my God.
he's here half the time, he's gotta go. Wait to speak.
Oh, my God.
Oh, yeah.
First,
Oh, that's awful.
significant other.
Has an outside one, that's. Dig in every time.
What's that thing that Charles Barkley has?
But every day.
You know, where you lose about 30 pounds.
HBO Max.
So much. And I love it.
Yes.
I love it.
You support. I don't think we. I agree with that. I agree with that.
Now I can, when I look.
Michael, anything new? Anything new?
I understand why.
I can't believe
I don't think you're gonna say anything. You're gonna speak.
You know, it's hard.
Make that comment. Just run along.
Get this.
And I'm, you know, you take a look at the evidence list.
The way I would, you don't know, you're right there near her.
It's the perfect time.
And the recent incidents similar to this.
One
Meetings. I got a response to that.
Had other cases, we had the dog. Yeah.
You take a look at the grievance list. Sends out every night. No, this is the historical. Yeah, but I'm saying, what that, you'll find the dog.
Yeah.
I said to her, I think that guy.
Nice one, back.
Should we get more seats?
Yeah. You are. Right, she's correct. Correct. I agree with that. For that, and they sell their second.
Like the whole sentence.
I
Like you're gonna that's by your house, right? Of course.
You got 8 seats.
Warming.
When are we gonna start holding this in the hall of Chapter?
They're not saying that. Oh my God.
Feeling a little stirred.
I'm proud of you.
So that one had lunch.
Same business. Did you have those?
No, no, wait, I drafted them first. Greg took this on. Yes.
Yeah, I talked around the phone.
Yeah, I mean, I did my month. Yes, I am. Yes, I am.
I'm not, I'm just a mercy.
No, you're more than that, my dear. Serious, serious. What? Crazy, crazy.
We love that. Getting close to you.
No.
So her ticket, getting back her license, which shouldn't be.
I don't know about the ticket.
She's driving at the speed. She was speeding, so she got pulled. She was getting.
That I'm aware of. 9 miles.
That's okay. Then they took her license because her license has been suspended.
Caramel Plus.
So we're.
They took her license. So we had, it turns out it was an insurance company because we never had a lapse in.
Yeah, that's the list. 6 months.
His dog.
Look at the dog.
So
There.
she had to pay.
Everything.
Or else they wouldn't have.
Say number one.
But now the only people we have challenged is the insurance company because it's their fault.
I'm gonna change the back. I don't want to make sure.
This is it. Yeah.
There he is.
Michael? Yeah. I'm gonna fix it. I
No, thank you.
What I said, they'll hand it back to them.
No.
I don't think.
And if you, well, you know what? In baseball, if you don't swing, you never get a hit.
First of all, you got.
We did, which was in Lake Worth,
Why?
because that was the soonest we could get. And she rightly so didn't want to ride her out.
I can't,
Is this for registration or?
why would you need?
It says on there something's wrong, but that gives no form of identification.
Right.
I was not happy.
I know that Glen Eagle's membership card is not a form of identification. It's valid.
You remember when we had to have cards for people that have dogs, had to have a card for their dogs? She didn't even went to lunch and didn't have her card, so she showed the dog.
Dogs at one point had to have their own membership.
Yes, to show they were registered.
They had to carry it with them.
And they had, yes, the dog had to carry with them.
Better than the last couple.
And someone came to lunch. and
That's actually pretty funny.
they didn't have their card, and that's what.
That's actually pretty.
$2 if you didn't have the card.
Like she's the new.
I do remember the charge if you, I remember that.
So, pulled out the dog.
And it was,
Have their card, but.
Can we give out neck lantern so they can get word?
I think it's registered.
Not in my wheelhouse, but I was hysterical. I couldn't stop.
Jackets, jackets, you can put the card in the jacket.
I think we should have
30 seconds.
it's tattooed to our arm. So I would put a tattoo there.
Take that back. No, one thing before you start.
I got a bad history.
So.
Right. As I said it, I went, nah.
You registered, yes. They never
You
did.
do? You know, we had properties that we went on. We actually took the DNA of the dog. So if a dog is replicated, wasn't picked up, we were able to send it to the lab and tie it into that. So, yeah.
There's that way. My dad.
This was student housing, so they never picked it up.
Call the meeting to order. I want to welcome everyone who is in attendance today. This meeting is also being broadcast on channel 63 on YouTube, and we have many members on Zoom, as you can see on the screen. A reminder to the governors and anyone who has asked to speak, please speak clearly and loudly, because of the microphone sometimes has a problem picking up soft voices. So for the benefit of those streaming or otherwise zooming in, please speak clearly. Also, if you have any electronic devices that may ring, buzz, chirp, or otherwise make a noise that would be somewhat distracting, please turn like that. You, Trudy.
I just wanted to turn it off.
Thank you very much.
I wanted
You
to.
can't, I couldn't have planned that.
Made that up.
I think you did plan it.
For those who have asked to speak, when the item for which they want to address on the agenda is reached, I will call that person or those people, and you'll be given 3 minutes to address the board. Turning to the agenda, concerning the notice of today's meeting. Roger Padover executed an affidavit of mailing and posting of notice of this meeting, in which he affirms that the notice of this meeting mailed by U.S. mail or transmitted electronically to all members of record of Glen Eagles Country Club Incorporated at least 14 days before the meeting, at their latest address on file with Glen Eagles Country Club, and that the notice for today's meeting was also posted conspicuously on the club's property at least 14 days before the meeting. A copy of that affidavit shall be attached to the minutes of this meeting as Exhibit A. Turning to the approval of minutes from the April 23rd, 2026 board meeting. Those meeting minutes have been previously circulated. Are there any additions or corrections to those minutes? I have to keep looking at Mr. Feldman over in the corner there. Hearing none, then those minutes are approved as presented. Turning to my report. The agenda for today's meeting is lengthy, so I will make my report brief. Among other matters, the agenda includes consideration of numerous motions related to the proposed clubhouse renovation. Those motions concern an agreement with Mao Associates, the general contractor, and numerous agreements and notes with the Bank of America, together with resolutions to provide financing for the renovation. Additionally, a motion will be considered regarding an increase in member debt service assessment. I want to acknowledge and thank Craig Spina and his leadership team for the hard work and long hours they have invested and continue to invest in the planning of the renovation, the planning for operations during the renovation, and the communications to the members throughout the process. I also want to acknowledge and thank the Budget and Finance Committee for its careful consideration of the proposed renovation and its financing, as well as the committee's recommendations to the board to proceed. The proposed clubhouse renovation is by far largest and most complex project undertaken by Glen Eagles to date. It is a very exciting undertaking and will bring Glen Eagles to a whole new level. With that, I'm going to turn it over to Mr. Spina for his general manager's report.
All right. Well, good afternoon, everyone.
Afternoon.
And thank you to those that are tuning in on YouTube and Zoom. And thank you for those that are here in person. Just a real quick project update. If you haven't seen them, out on the driving range containers, which is kind of one of our first milestones when it comes to things you're going to see. The next thing is obviously you definitely cannot miss the tents that are there. I think after setting them up, it's favorable in the amount of space that we have between the tents and areas for the members to move around, walk around safely. So you'll be getting something in an email in a little bit. It's going to ask our members to be careful when they're navigating around this area. We've started to put up red markers around the stakes, and we're trying to make it bulletproof. We know it won't be, but we're trying to make it bulletproof safe. And you will probably see it's somewhat fluid. You'll see some changes in the way that we operate just based on what works the best. Originally decided to put the carts in lengthways. I think we'll keep doing that because we can fit probably close to most of our carts in inventory under the tent, which originally we didn't know. But when it comes to staging, it may be a little different. So in any event, the next big step is we have to get power to the tents, which means pulling it from the sub panel over here in the cart barn. We'll go under the pavers, and then we'll go to not only the tents, we'll go to the containers, because the containers are air conditioned and they will keep the clubs and all the stuff in your clubs, keep the humidity out, keep them dry, keep your grips from getting sticky when they're in the sun for 6 months. So that will happen next. I had an email question about VEs, about changes, and just for the record, there have been essentially no VEs, folks, to this project. Okay, we're 2 years into this project or more. We asked for the platinum level, as it would serve Glen Eagles as a platinum level, and that's where we sit today. We will have some conversation. There are some areas that we're going to look at. That is it servicing the members the best? Is it going to present the best? And from a cost perspective, is there an opportunity to modify this and exceed the expectations of what they see, or do we leave it alone? So there's still a lot of moving parts when it comes to not pricing so much, but to we see. In fact, probably next week, my staff and I will have to sit down. We'll sit down with IDDI, and we'll do what we call page flip. And there's about 300 or more components. There lounge chairs, there's a sofa, there's finishes in the floor, there's any of the furnishings. We're going to do a page flip. And a good example is Legends Dining Room. Legends Dining Room, we can't live with 190 seats, and it's because they're large seats, they're large tables. So what's an alternate package for this area to give us more seating, still looks wonderful, is comfortable, and from a cost perspective works. We do get to do sit tests on anything, not every couch and every big comfortable chair, but your ladies' card rooms, I can assure you we're going to do sit tests. Men's card room, dining room, veranda, those are big volume chairs. You get to check them out. The bar stools, they're gonna move, they're not gonna move, they're gonna have arms, they're not gonna have arms. We're gonna listen. Those are not questions that we asked in our investigative side because we didn't need to know right now. So they've selected different types of furnishings. We'll go through the page flip, and then that's when we have to kind of commit to, okay, yeah, we like these. You will all be involved. If you saw those dining room chairs and you remember they're big kind of bucket seats and there's stone top tables, if we come back and say, okay, listen, those aren't going to work. Here's 2 selections that do work. You're going to have a say so. Okay. Unilaterally, we don't make unilateral decisions. Any kind of changes that are significant. If the guy comes out to us and said, hey, I gotta make this minor change in the ceiling, in the tiles, and it's not going to impact, we're going to make a call in the field. Big picture changes, you will be involved. Budget and finance will be involved. OAC will be involved. Board has the ultimate decision. So when it comes to, and everybody's agreed that, hey, this is the direction we want to go, we're going to sit down and we'll make decisions. So make sense? Okay. we're going through, we're on our third round of project costs. By reducing contingencies on contractor side, by reducing ours a little bit, I think we're still at 7% contingencies still at 54, which, God bless, which has been our goal now for many, many months. So we got to 54 million because we had to drop contingencies a little bit, was always the plan. You weren't going to keep, $8 million in contingencies through the whole project. Okay, so the closer the contract gets to a firm number, which are 95% now, sign a GMP contract, they're committed to that number, their contingency should be weaned down to a contingency that's going to give them a little bit of latitude. I think we would all agree we keep ours closer to the $3 million mark because we might need to make a change in the field. Now, I don't know what they are at this point, but when they do come, you will be in the loop and you will be the ones making the decision. So we are on our third iteration of costs. No VE to date. The GMP contract, we're on our third round with the attorneys. I think we've whittled it now. I think the next step on the GMP contract is get on the phone with contractor, I imagine their attorney, our attorney, and iron out the few remaining changes. Something that I will bring to the board at some point is shared savings, which we haven't discussed yet, and also milestones. Shared savings means if they decide to do it. I did ask Josh about shared savings and his OHP, which is 6.5%. And I kind of got that, but you give a little, take a little. So we will come back to the table for shared savings. He did say, listen, shared savings at the tennis center, we all know we did pretty well. Said in a renovation and not a new construction project, it could be a little bit different. I said, listen, that's up to you. And I said, but also milestones. He said the shared savings is motivation for his team. Milestones, motivation for his team. And it's obviously motivation for us, meaning milestones. So we get to where we want to be at the time we need to be there. So those are still out there. I've asked him to think about it. It's not new to him. Jesse's got 3 projects right now where they're doing shared savings. So we can kind of see what these other clubs, how successful they've been. We are talking about insurance. Okay, I haven't even looked at it. I just got some information back from Mauricio on not on bonding, but on insurance, OSIP, CSIP. We'll talk about that. Again, I don't know what to report because I haven't had a chance to look at that yet. The bank docs are complete. I think we've gone through those with the attorneys a few different times. So those are ready to go. That's it on the project, unless you have questions. I think that we've had a lot of conversations recently, a lot of questions. Everybody here's been at the tables, been in the meetings, has heard what we're doing. So I think you should be up to speed on everything today. Okay.
Any questions, Craig?
Thank you.
Thank you. Next, Secretary's report.
We just received one little note. It's from Shelley Markinowitz Golding, and she's expressing her gratitude for giving her the opportunity to create the Living Your Best Life Weekly Club.
Nice. That's it. Treasurer's report, Mrs. Cleo.
For the month ended April 30th, 2026, we recognized a $50,485 operating budget surplus. Year to date, we are recognizing a $137,788 operating surplus compared to budget. Sales to date in this fiscal year are 63 sales, with 47 being new members. And at this time, we have 3 in the pipeline. In the prior year at this time, there were 38 sales, with 31 being new members. Net proceeds after accounting for refunds of second units and bonds are in this current year $5,220,000. In the prior year, $2,912,500. At this time, the MLS shows 16 condos and 1 home for sale. The average age of new buyers is male 68.1 and female 67.4. Average age of sellers is male 76.9 and female 77.7. On the golf and tennis transfer list, we have 73 golf memberships and 44 tennis. There have been 62 golf and 97 tennis memberships removed since the inception. As of April 30th, 2026, there are 343 social members. Solo members, solo. There are currently 2 suspended memberships due to financial delinquency. The board will vote today to suspend 2 more members. The club at this time does not own any units nor have any sports memberships in inventory. For golf, in April, there were 5,928 rounds played, 22 less than budget. Compared to prior April, we were up by 3 rounds. Year to date, 39,965 rounds have been played, 725 rounds less than budget. Compared to the prior year to date, we are down by 1,286 rounds. Food and beverage. In April, the total covers, including to-go, of 902 were 14,220. The budget for April was 150. Last April, the actual covers were 12,869. Year to date, the total covers, including to-go, of about 5,241 or 100,734, with a budget of 101,284. The year to date in the prior year was 100,964. And due to the fact that Harvey Grunwald could not be here, I'm just going to let everyone know that as of this morning, we had $9,814,313 in the bank.
Have it one more time, Trudy. Let's repeat that again, please.
$9,814,313.
Any questions on the
One more
treasurer?
question. What do we expect for new member capital contributions coming from sales in the pipeline? How much more?
There's only one that I know of the 3 sales in the pipeline at this time.
Another 100?
110. There could be more, but at this point,
That's all we know about.
at this time.
Okay.
You may not know the answer, but Harvey here. So the 9.8 million in the bank represents, or you might know, represents how many closed sales? What I'm getting at is how many sales have not closed? Because I know we calculate the new member capital contribution of 5 point whatever, but it doesn't reflect cash flow. Do we know?
I thought it was 1.5 million was outstanding.
It's not, yeah, that's about it.
We're closer to 11 million
Right.
once we close.
Right.
Okay, just.
And one other thing is, just so everyone understands about the bank balance, there is still approximately 1.8 million of current capital budget to be spent. So that's got to come out of that also.
So just on that note, we have and will continue to go through it, because every year, if you have $1.2 million to be spent, either whether it's timing, whatever case, it may not be that number. And of course, there's always the unbudgeted ones that we've already done, which come up as rises, emergencies and things like that. So we'll continue on a monthly basis. Harvey's not here, but we'll continue on a monthly basis to update so that you know where we sit with that $1.2 million.
That's what we did. That's what he gave me as of
Yes,
yesterday.
right. And we'll update it again and just keep.
Right, continue to, right, oops. Oh, he just, I just heard from him.
I'm gonna go lay back down.
Are there any other questions for regarding the treasurer's report? Okay, we'll move to new business. Item A is consideration of a motion to approve the clubhouse renovation. And Mr. Horowitz, you asked to speak.
Yes. I will tell you, I'm Marvin Horowitz, and I've been a member of Glen Eagles Country Club for, I guess, 37 or 38 years. And by the way, it's not because of Harvey relationship with your esteemed president that I'm speaking today. I haven't discussed with him anything that I'm going to say, except I did tell him I wasn't really going to say anything against it. But I have been here enough so that I have seen the changes over the years. When I first got here, you wanted to hit golf balls out on the range, you bought a token, paid for it. And things have gone along very well. And yet some have spoken with me, why do we have to go through this expensive renovation? Why is it necessary? Well, I want to give you my feeling about it. I have watched the improvements in Glen Eagles Country Club over the years, and it's been getting better and better and better. And I will say, it doesn't have to get better for my age group, but there are younger people coming in, and it's a great country club for everybody. And I just hope that you all will vote in favor of all of these resolutions to go forward with the renovations. And I compliment all of you for having worked incessantly to get through to this date. And my very, very strong appreciation to Greg Spina, our manager.
I was not a coach. Mr. Spina, I understand you would like to speak on this issue.
I'm going to read something, if you don't mind. I'm going to stand over here because it's not good to have. Well, for those of you who's my bad, so I apologize. So before we move to the motion and vote regarding proposed $54 million clubhouse renovation, I'd like to take a moment to recognize the significance of what stands before us today. This decision is not simply about construction, buildings, or dollars. It's about the future of Glen Eagles Country Club and the responsibility we collectively carry to preserve, strengthen, and position this community for generations to come. For the past many months, there have been an extraordinary amount of work, analysis, discussion, and thoughtful debate undertaken by the board, the Budget and Finance Committee, the OAC, management, and consultants, and countless members who deeply care about this club. Every question asked, every concern raised, and every alternative explored has reflected the seriousness with which this responsibility has been approached. No one takes lightly the magnitude of this investment or the impact it will have on our membership. At this time, it is equally important to recognize that standing still also carries consequences. Our responsibility as leaders is not only to protect what Glen Eagles is today, but to thoughtfully prepare it for what it must become tomorrow. What makes this moment meaningful is not simply the renovation itself, but the care, integrity, and collaboration that have guided this process. This has never been about individual preferences. It has been about governance, stewardship, transparency, and doing what is the long-term best in the best interest of the club as a whole. The proposed renovation represents far more than updated facilities. It represents an investment in member experience, in operational sustainability, in the value of our community, and in the legacy we leave for future members and residents. It is intended to create a clubhouse environment that reflects the quality, warmth, and vibrancy of Glen Eagles community itself. I want to take this time to sincerely thank each of you, our leadership team, and countless members for the time, thoughtfulness, professionalism, and dedication you have brought to this process. These decisions are not easy, nor should they be. They require courage, diligence, and an unwavering commitment to fiduciary responsibility. Thank you.
Thank you, Mr. Green. Mr. Parrots, I understand you have a motion.
I do.
Would you please
It's my
present your
own.
motion?
I move to approve the proposed clubhouse renovations with a total cost not to exceed $54 million.
Is there a second to that motion? Feinerman, you were the first one. It was a race. Okay, motion is before us. Any discussion on the motion? Hearing none, I'll call the question. All those in favor of the motion, please signify. It is unanimous. Thank you. The next item on the agenda concerns the agreement with Mao. Do you have a motion with respect to that?
I do.
Please proceed.
I move, 1, to approve Glen Eagles Country Club Incorporated entering into an agreement reviewed by counsel for Glen Eagles with Mao Associates, Inc. for the clubhouse renovation, together with a guaranteed maximum price amendment and exhibits thereof not to exceed $39,500,000. And 2, to authorize Greg Benson, President, to execute that agreement, amendment, and exhibits on behalf of Glen Eagles Country Club Incorporated.
Is there a second to that motion? Mr. Wasserman. Discussion. Okay, I'll call the question then. All those in favor of the motion? Again, the motion passes unanimous. Thank you. Item C under new business. Mrs. Cleo, I understand you have some motions relating to the banking. And I will just make a comment before we address these, that all of these loan agreements and notes have been previously presented to you, and you've seen them on the Google Drive. So any reference there to concerns those documents as presented. So Mrs. Cleos, would you proceed?
Yes, I will. I move to approve Glen Eagles Country Club to obtain a loan from Bank of America for an amount up to $49 million and executing a promissory note with Bank of America for an amount up to $49 million, the terms of which as presented.
There a second? Mrs. Feinerman. Your discussion on this? Any discussion? Okay, call the question. All in favor of the motion? Again, unanimous. Thank you. Cleos, you have another motion.
Yes, this is for the swap agreement. I move to approve Glen Eagles Country Club, Inc. entering into a swap agreement for $47 million of the $49 million loan from Bank of America.
Is there a second on that, Mrs. Monk? Discussion. Okay, all those in favor? Passes unanimous. Could you speak louder, please? The speaker, you're gonna have to speak louder. I just got a note test. Next motion, Mrs. Cleos, you have another motion, I understand.
This is regarding reinstated notes and agreements. I move to approve Glen Eagles Country Club, Inc. entering into the following with Bank of America, the terms of each as presented. 1, a restated line of credit in the amount of $2 million and a promissory note. 2, a restated promissory note for the balance of the existing Healthy Lifestyle Center on the loan on the date of closing. A reinstated promissory. Restated. A restated promissory note for the balance of the existing Community Maintenance Center loan on the date of closing. 4.
Jesus Christ.
Please put your speaker on mute.
He's been doing it as everybody comes in.
Number 4, an amended and restated security agreement. And number 5, an amended and restated negative pledge agreement.
Is there a second to that motion? Mr. Kavanaugh. Discussion on this motion. Mr. Pope. Okay, hearing no discussion, then I'll call the question. All in favor of the motion? That's unanimous as well. Okay, we're getting there. A lot of these we have to do. So Mrs. Cleos, would you continue?
Proposed motion to approve amended and restated loan agreement. I move to approve Glen Eagles Country Club, Inc., entering into an amended and restated loan agreement with Bank of America, the terms of which as presented.
Is there a second on this motion? Mr. Watson. Okay, discussion. Okay, no discussion, then I'll call the question. All in favor? Again, unanimous. Okay, thank you. You have another one?
This is my list.
This is,
Proposed motion to adopt resolutions. I move that the resolutions presented for consideration today be adopted and then a copy of these resolutions be included as an exhibit to the minutes of today's meeting.
second on the Heineman. Discussion. Okay, call the question. All in favor? Motion passes unanimously. I believe you have one more. Oh, yes, you do.
Well, where is it?
It's the service credit line.
Never got it. I move for consideration of a motion to increase the member debt assessment from $215 per unit per month to $420 per unit per month, beginning July 1st, 2026.
Is there a second, Mr. Kavanaugh? Discussion on this motion.
I have a question.
Please. No, we don't allow questions. If you haven't signed up to speak, we're in the middle of discussion. If you're not a member of the board, there's no question. Any member of the board have any point of discussion? Okay, I'll call the question. Yes, Mrs. Harrell.
Can we just once again make it clear that the 420 is the assessment? It's
The
not
total.
an additional, it's the total, $420.
Thank you. Again, we can say it in many, many ways. It's an additional $205 for a total of $420. To be clear, as the motion states. Okay. No further discussion. I'll call the question. All in favor? Okay, that motion passes unanimously. Thank you. I don't know why you didn't have that.
I did.
Yeah.
I'm
Okay.
sorry,
Okay.
but I did.
All right. Next item under new business, item J. Mr. Wasserman, I believe this is a matter.
Aye.
Aye. I'm sorry. It's not, I jumped. Aye. Aye.
Actually, I'll describe the rule first, if that's okay. Section 18.15 reads, any type of covering for cars, motorcycles, scooters, and mopeds in parking lots is prohibited. Violators of this policy will be responsible to remove the covers, and neighborhood associations may file a grievance against the owner. This policy excludes bicycles parked in neighborhood association designated bike racks. I move to strike Rule 18.15 its entirety and renumber Rules 18.16 and 18.17 as Rules 18.15 and 18.16 respectively.
Second to that motion, Mrs. Cleos. All right. Do you have any comments you'd like to?
I do. Yeah, this is not a vote on whether to permit this or not. The associations own the streets in their association.
Right.
They should be responsible and decide what's best for their association. That will differ from one association to another. It should be put in their hands. So this is not a vote to approve car covers or not. It's just to shift responsibility to the associations.
Discussion. Mr. Phelps, Ms. Cohen first and then Mr. Goldberg.
Yeah, so I understand that, Michael. And over the past several years, we've definitely been proceeding to shift responsibility to the COAs and the HOA of items that really should not be under the board's governance. That said, I read the email today that came in from one of the COA presidents that essentially asked for, I understood it, a little more time for them to respond. I don't know if Greg or Craig can shed any light on this, but I would like to give them an opportunity to weigh in on this. I recognize the summer is approaching and the like, but if at all possible, I don't know whether you could take it to President's Council or the like, but I certainly don't want to act heavy hand if the POAs have a different view and they need time to adopt their own counterparts.
I mean, I think that it's a conversation that could definitely be had with the President's Council. What I would provide information on is, listen, if I lived here, I would hope that I could put my car under a car cover. Sorry if I've tainted the water here, but I know what the water comes out of these sprinkler heads, and this reclaimed water is kind of tough on the vehicles. I think the key is to keep consistency, to make sure they're not coming off the cars in the middle of the summer and the person's on vacation, and making sure the community and the parking areas is kept. With that in mind, I think there's ways that we could potentially do that. And I'd be happy to discuss, I'd be happy to prepare for the meeting, give them some options. As far as having a clear license plate, I don't know what why we would need to do that. These cars aren't moving. But anyways, I'm just trying to think if a vote would change that one way or another. The club not having, I guess it's communication. The club not having, it would then bounce back to the associations. And if the association did or didn't have a rule and somebody puts a car cover on, they could either say, hey, sorry, we don't have a rule, take it off. Or they could say, take it off. And the resident could say, well, we have a rule that says we can't have. I'm not aware of any associations or you that has a rule which states that they can have car covers. Yeah, I am not fluent enough on the documents. So
I think I'm next, Michael. You are.
If you wanted to wait, that's. Yeah.
So a couple of things. I mean, one, Craig, you mentioned consistency, and by approving, by supporting this motion, you're doing the very opposite, because what you're doing is you're throwing the issue of car covers to each of the individual associations, thus depleting consistency. I want to read a little something that I prepared earlier today. So, as I understand it, the predicate of the motion is that the associations, not the club, own the parking area. I believe that the club has the authority to maintain Rule 1815 pursuant to Article 19.03 of the amended Declaration of Protective Covenants, which reads that the corporation may, in accordance with and furtherance of the overall plan, the development of Glen Eagles as a uniformly landscaped, designed, and maintained community, maintain, repair, and replace as necessary any neighborhood's neighborhood maintenance areas in a neat, aesthetically pleasing, and proper manner. I don't know that the club is engaged with the neighborhood associations on this issue. In my view, the neighborhood associations do not control vehicle. If the neighborhood associations do not control vehicle covers, then it is the responsibility of the club to control same, pursuant to Article 19.03 of the amended Declaration of Protective Covenants, so that the neighborhood associations will be maintained in a neat, aesthetically pleasing, and proper manner. I also believe that eliminating Rule 1815 is inconsistent with the terms and provisions of the governing documents and is not allowed by the club's amended and restated bylaws, Section 8, which provides the board, may adopt rules or amend, modify, or rescind then existing rules for the operation and use of Glen Eagles, provided, however, that such rules are not inconsistent with the terms or provisions of the governing documents, which I referenced above. If the motion were to pass before the neighborhood associations were able to address the issues and various members were to install car covers on their vehicles, the genie would be out of the bottle and might not be subject to once again going back into the bottle. I move to table the motion until such time as the club is engaged with the neighborhood associations on this issue and can inform the board of the progress or lack of progress that the neighborhood associations have or will make in controlling vehicle covers.
Is there a second to that motion? Mark? Any further discussion on the motion that is before us to table?
We set a date, Mark, to table it to?
Yeah.
Moving to table.
45 days from now.
Okay.
So you're amending your motion?
I'm amending the motion to prohibit that it be tabled for until 45 days from now.
That'll put some steam to the COAs for them
Ms.
to.
Moss, do you accept that amendment?
Yes.
Okay. There's a motion to table for 45 days, the original motion. Is there any further discussion on the motion to table? Mrs. Howard?
Mr. Pearl, in his letter, asked for a possibility of having some waivers for people who are not here, won't be here for another 4 or 5 months, and who have car covers currently on their cars.
Nobody else.
No one has them now, or want to put them on.
That's a difference.
That's a different story.
I want to be able to cover them as a waiver until this is decided.
Who's giving them permission to do it?
Yes.
Gotta speak up.
So in the letter that Mr. Pearl sent to the board, he is asking if no decision is made on dropping that original motion, and we do table it. Is it possible to get waivers for those people that would like to use car covers until this is decided?
Is that
That's not properly reported. That's not the
Right.
it's not my motion?
No, it's not the motion.
Right.
So yeah. Thank you for raising that, but it's not
Well, I wanted to raise it before I voted on that.
fine.
Just in the consideration of 45 days, that goes beyond our next, right? So 45 days falls somewhere between, I'm guessing, between our meetings. So we're really either doing it 30 days or we're doing it 60 days, approximately. So it's either we're postponing till the next meeting or till the meeting after. To me, I just thought 45 days is, because we're going to discuss it in one of those meetings. That's all. So just for your consideration, maybe we would just do it at a specific thing that we have this discussion. That's all.
I'm happy to further amend my motion to table the motion until the second meeting following this meeting.
Why?
Ms. Moore,
August.
do you accept his motion as amended twice? Any further discussion? I'll call a question. The question is before you to table the original motion for two more board meetings and be revisited 2 months hence. All in favor? Okay, that motion is tabled.
So Craig, you're gonna run with this, right?
Yeah, my question, to give me a little guidance, there's two components here. One is presenting something to the board that they feel comfortable. The other is meeting with the president's council and having a conversation. I'm not looking to get to set a precedent, to set rules for each association. We're looking for general consensus to keep it consistent. That's going to be up to the association. Yeah, we buy off on this or we don't buy off on this. What I would like is some guidance and maybe a conclusion from the board to sit with me and say, okay, Craig, here's the kinds of things that we need to bring back to the board. Can't just go sit with the president's council and say, okay, guys, what do you think we should do? Come back and you go, that's not what we're looking for. So maybe,
I would
okay, if
I made the motion.
three of you could sit down and say, okay, whether you're in favor or not, yes, please.
I was just hope that within the 60 days, so my original discussion when Michael brought up is that we make it, instead of doing that, which I'm fine with, was make it effective. We could vote today for an effective date. However, 60 days from now, that being either way. Just so, but I think I don't want them to not prepare for, if we vote on this in 60 days, that they don't have an idea of how they're going to do it. So that's all. That should be part of the discussion.
I would have that well before.
Didn't we just pass a motion to table this for 2 months?
Right. So the original motion will not come up for 2 months.
Right.
So.
Right. My point was just that in his discussions with that they're prepared at that time to know what they would do if we then vote to rescind the
I
rule.
understand.
That was
I'm
all
sure
I
We
was
have plenty of,
That was his question.
we'll get together.
Good. Thank you. Okay. Next item under new business. It's been, we voted.
We didn't know.
You didn't vote to table?
No.
We never.
Yeah, I called.
We did vote to take.
Did you?
Yes.
Yeah, we did vote.
We did. I raised my hand.
You voted.
I raised
Oh, yes, I raised my hand.
Yeah, please. I did call the
All
question.
right, where's my other motion?
Under new business, item J.
Yeah, now I can't find my
Yeah,
motion.
Mr. Goldberg is digging through his.
I found my motion.
Okay,
I move that subject to the execution of a purchase and sales settlement / mutual release agreement, and the agreement by and between Glen Eagles Country Club Inc. and the club and the owner of unit 1207-7465 Glendevin Lane and the unit for the purchase of the unit, together with the approval of the agreement and the purchase and sale of the unit by the United States Bankruptcy Court for the Western District of Tennessee, that the club purchased the unit for the amount of $75,000, together with usual and customary closing costs that are incurred in the purchase and sale of real property, that the club be further authorized to satisfy the property taxes owing on the unit at the time of purchase, in such amount as will then be necessary to satisfy same, that the club be further enter into a subsequent agreement with Glen Eagles Condo One Association if needed regarding condo association dues that may be owed by the owner of the unit through the time of the purchase of the unit, and further authorizing the president of the club to execute any and all documents necessary and or appropriate to effectuate that above set forth.
second to that motion. Mr. Cohen, would you like to give a little bit of background, Mr. Goldberg, on this motion?
Yeah.
Or further discussion?
Yes. The unit owner, on the 31st of December of 2025, filed a Chapter 13 case in the bankruptcy court in Western Tennessee. Prior to the filing of that case, the club accelerated the obligation owed by the unit owner, and the amount presently owed is approximately $42,000. The club engaged Tennessee Insolvency Council to represent its interests. A secured proof of claim was filed with the bankruptcy court in the amount that I indicated just a moment ago. And our debtors council, the unit owners council, asked if we had any proposal to help in resolution of the matter. The club did not respond to that request, but rather indicated that if the unit owner had a proposal that he or she wished to make, that proposal could be made. Subsequently, the unit owner debtor filed a motion objecting to the claim, which is filed as a secured claim, which would impair the club's rights to collect all of the money owed if that objection was sustained, and further countered with a proposal that the club acquire the unit in the amount of $75,000. The club did an analysis of the obligations owed, an analysis of the anticipated market value of the property, and an analysis of timing as to when, if there were no resolution, a settlement resolution, how long the matter might take. In addition, the court directed, should there be an objection to the claim hearing on the 9th of June of this year, that the club make available and present an individual to testify at that hearing. So in the context of all of that information, the ARAC committee considered and suggested that the club accept the offer of settlement made by the unit owner and that the club purchase the property for the amount of $75,000 together with the additional items that were identified in the motion that I just made.
Thank you, Mr. Are there any questions or discussion regarding the motion? Yes, Ms. Cook.
I just want to tell everybody, Mark did a phenomenal job on this.
Good job. Thank
They
you.
literally saved us thousands and thousands of dollars. But even more important than the money saved, relying on your expertise in this space ensured that we got the right result. We're going to get all our money back on this one. And would have happened if you didn't do it. We appreciate that.
My pleasure.
Thank you.
Any other discussion or on the motion? Yes, Ms.
I'm
Weinstein.
curious, when was the last time we owned a property?
That's probably the one that Mitch Marin bought from us.
Okay, so not that long ago.
Yes,
Anyone?
yes.
We owned it. We've owned probably 4, maybe 5. We've had 2 or 3 stay in plays. We've had ones that we foreclosed on banks and they just handed it off to us. I think our goal should be sell it, do member capital contribution, cover any debts. We do have an agreement with the associations, which gives them their pro rata share of what we collect after we've settled the debts. And then Catherine did find the contract that we use for one of the associations, probably the right contract to use for the other ones. And once we get to a point when we're ready to close, sell it and all those things, we will definitely provide this information to the board. So, because you'll have to approve it.
Okay, thank you.
Any other discussion on the motion? Well, then I'll call the question. All in favor? Motion passes unanimously. Thank you, Mr. Goldberg, for all your hard work.
Thank you. Thank you. My pleasure.
After the meeting, you can
The next 2 items under new business concern grievances. I will just make some general comments with respect to the grievances. Now, under our adopted finding and suspension of use rights procedures, the board does not conduct a hearing here. We have the benefit of the report from the Grievance Investigation Committee. And though we have some people who have asked to speak, but there will not be any questioning or anything like that, because that's not the purpose of the board considering the grievances before it, to engage in any sort of interrogation or examination. If the board does levy a fine and or suspension, there is a right of hearing, and notice will be given, and you have a right to attend a hearing, at which time you can present evidence to why the board's decision should not be confirmed by that committee. That's the process we will follow. And with that, the first grievance on our agenda is Grobstein versus Urshowski. Now, Ms. Grobstein is asked to speak and Mr. Urshowski is asked to speak as well. So, Mrs. Grobstein, you have the opportunity. You have 3 minutes to address the board.
Thank you.
Okay.
My name is Gloria Grobstein. People call me Gigi, but I don't really use Gloria. But I appreciate the Board of Governors letting me speak on my behalf of what happens to me on February 25th, 2026. I was going into the off of Linton into the gates and heading straight. I've always stopped at stop signs, especially 4-way stop signs. I, at the time, saw a silver car that was stopping at the same time. I had the right of way. I continued straight and I was on the right-hand lane. the person who was at the time, I did not know, was eventually turning from Victory, and going up over the, the other side and making a left onto Legends. At that time, when the person was turning, about a few minutes, like few seconds later, all of a sudden I heard honking, and it was continual. I didn't know what the honking was all about. I just figured I'd slow down. I went to the left side behind the person who was honking at me. I had no idea, and continued straight. All of a sudden, the person in the car that was honking at me, oh, and by the way, honking at me, shooting me a birdie, and also screaming something, but my window was closed. So I was going straight, and all of a sudden the car in front of me, the silver car, stopped. I stopped behind him. Before I even knew it, the person was out of the car coming towards me. I was alarmed. I didn't know what was happening. I didn't know why it was happening, but I literally put down my window a little bit and said, and I heard him saying, "You almost could have caused an accident. Don't you know I'm going to report you?" I'm like, "What do you mean we almost caused an accident?" He's like, "Well, you didn't stop at a stop sign." I'm like, whoa. I stopped at the stop sign. I was very clear. I've never not stopped at a stop sign at Glen Eagle. Then continually screaming at me, cursing at me, and then took out his camera, and I realized it was afterwards Sherm Urshowski, and started taking pictures of me, or trying to take pictures of me. He's like, "I'm going to take pictures of you. I'm going to show everybody what you've done, what you could have done." I'm like, I didn't do anything. Our cars were not even anywhere near each other at any time until he pulled next to me. Well, I was going straight, and he was turning.
Been 3 minutes already, and
All right.
we've seen most of this.
For you, I'm going to show everybody what you've done, what you could have done. I'm like,
Thank you.
So anyways, it became, verbal abuse, road rage. It was crazy. I always felt safe in Glen Eagle. I did not feel safe. I did not feel protected. He followed me after I left in parked behind me when I left, and followed me to another space in Glen Eagle and started taking pictures again. He took pictures when I was on Victory. He apparently.
I'm going to have to cut you off. We have all this in the report already.
All right.
So
Well,
thank you for sharing. And
all I want to say just quickly
please.
is that I feel that it might have a 17-year-old. Who's a driver. I don't want anybody else who is going to drive in Glen Eagle to feel that they're going to be road raged. All right. So young or old, I don't really care. I want to protect people from future stuff. If somebody is not fined or reprimanded and suspended,
Thank you.
I feel that.
Thank you. Mr. Urshowski. Here. Hello. Wherever you're comfortable, but if you speak up so
We can hear.
Okay.
First of all, I want to apologize to Ms. Gropstein for actually getting out of my car, which I shouldn't have done at any reason. The facts of the case and all the information is included in the report of grievance investigation. I obviously violated amendment bylaw 9.1 by getting out of my car. I don't deny that. That's all I'm going to say, because the rest of the information is in the report, which I'm sure.
Thank you. That's very good. Okay. All right. We've heard from parties requesting to speak. Is there a motion with respect to this grievance?
There is. Up here. I move that Sherm Oshowski violated section 9.1 of the club's amended bylaws and Article 21, miscellaneous rules, subparagraph number 3 of the club's amended rules by engaging in a course of improper conduct, including harassment.
Richard, we're having a volume issue here.
Can you hear me or no?
It's very muffled. Your voice is very muffled.
Yeah.
Is this any better?
Better. Yes.
But, hold on 1 second. Hold on.
You're muted.
No. Can't hear you.
Film your.
Not yet.
Somebody else can read that motion.
I was about to say.
Wait a minute. We can. Sorry for the technical difficulty here.
Greg.
I can read it.
Richard, if you'd like, we could have someone else handle the motion.
Oh, he's on mute.
Can't hear you. We assume he said yes.
Yes. Yes, Jack, Mrs. Feinerman Mrs. Feinerman will present your motion for you.
I move that Sherm Oshowski violated 9.1 of the club's amended bylaws and Article 21 miscellaneous rules subparagraph number 3 of the club's amended rules by engaging in a course of improper conduct, including harassment and disruptive behavior, which interfered with the comfort of member Gloria Grobstein. In particular, on February 25th, 2026, Mr. Oshowski made a left-hand turn from Victory onto Legends and allegedly was required to change lanes to avoid colliding with Mrs. Grobstein, who was traveling north in her vehicle on Legends. Mr. Oshowski claimed that Mrs. Groban failed to stop at the stop sign at the corner of Legends and Victory. Mr. Oshowski acknowledged that he yelled at Mrs. Grobstein and waved and pointed his arms at Mrs. Grobstein to convey that she failed to stop at said stop sign. Thereafter, both vehicles continued to travel north on Legends in order to reach their respective units on Glendale. While both vehicles were stopped at the corner of Legends and Clooney, Mr. Oshowski exited his car, approached Mrs. Grobstein, and confronted her, again claiming that Mrs. Grobstein had failed to come to a full stop at the corner of Legends and Victory. Mr. Oshowski acknowledged that he took multiple pictures of Mrs. Grobstein and her vehicle's license plate number in order to report her to security for improper driving. Mrs. Grobstein took multiple photos of Mr. Oshowski taking pictures of her. Mrs. Grobstein felt threatened by Mr. Oshowski's actions and subsequently contacted security regarding the incident. There is contradictory evidence offered by the parties as to whether Mr. Oshowski ever followed Mrs. Grobstein to her house, or that the parties each used inappropriate language or hand gestures either during or after the confrontation. Importantly, whether or not Mrs. Grobstein failed to come to a complete stop at the corner of Legends and Victory is not relevant to this grievance. What is relevant is Mr. Oshowski's conduct in exiting his vehicle and engaging in a course of conduct which, from Mrs. Grobstein's perspective, threatened her safety and welfare. Like reading the 4 questions.
Okay. Is there a second to that motion? Okay, Mr. Cadover. Discussion, Mr. Wasserman.
I'd like to request recusal.
Okay, Mr. Wasserman recuses himself. Is there anyone else who needs to recuse himself from considering this grievance? Okay, you're noted as recused. Discussion.
What? No. I have the penalty phase, Mark. This is just on the.
This is on the violation question. All right, I'll call the question. All those in favor?
You're a bankruptcy. Look.
Feldman, I assume you vote in favor of the motion? We can't hear you.
Raise your hand.
like this.
He can't hear us.
Can't hear us.
Can you write a note and hold it up? to him?
He was good to go.
Give him this or this.
All right, he can't, if he can't hear, then he can't vote on it. Okay. All right, so, one recused, Mr. Feldman couldn't hear, and everybody else voted in favor. Okay, now, next motion.
Having found a violation of section 9.1 of the club's amended bylaws and article 21 miscellaneous rules, subparagraph number 3 of the club's amended rules, I move that Mr. Oshowski be fined $100 and be suspended from the use of all club facilities for 1 week, all in accordance with the club's recommended penalty guidelines for infractions, and further be encouraged to provide a letter of apology to Mrs. Grobstein for his conduct.
Is there a second to that motion? Mrs. Moss. Discussion. Mr. Cohen.
Yeah, so this is a troubling fact pattern that we have experienced and addressed before. The closest case that I see in the grievance list involved an employee and had interaction with a member several years ago where the member approached the employee's car out in the front parking lot and opened the door. And in that instance, the member was given a six-week suspension. And the grievance list is replete with other scenarios where all of the suspensions are never less than a month, 2 months, 3 months. I know there was email traffic going back and forth among the board, raising the issue whether there's a distinction between the way
Figure it out.
employees should be dealt with versus members. We've talked about that many times.
Where am I? Where's Mindy?
My personal view is that there is no difference between members and employees. They both should be treated respectfully. Employees should have no less protection than members, and members should have no less protection than employees. That said, none of us like imposing suspensions on our members, but candidly, 1 week is far inconsistent with anything that we've done before. So I would not support the motion in its present form.
Are you offering an amendment to the motion?
I'm interested in hearing what other board members think.
Yes, Mr. Kavanaugh.
I'd like to move that the, excuse me, that the punishment be increased to a month suspension.
Okay, there's a motion to amend the motion to be a 1 month suspension. Is there a second to that proposed amendment to the motion?
Can I comment?
Yes, well, let's first get, is there a second here?
Sure, I'll second.
All right, so a second. Yes, Mr. Kavanaugh.
I think when Richard did his analysis, it was pretty thorough about when he was talking about Florida law and talking about harassment.
What's that?
Please make sure you speak loud.
He was talking about Florida law and about harassment and the assumptions that you make, as he put it, in Florida law, that somebody comes out of the car, they're packing. Okay, and so I think that we really need to take this idea of a threat seriously. I just, I wouldn't take any prisoners, with regard to an employee nor a member.
Mr. Goldberg?
Yeah, Sherm is a friend, but there needs to be consistency in the grievance process. And Art had already commented upon the apparent lack of consistency.
Hey, excuse me. Can you hear me now?
Yes.
All right. I apologize. I heard the last con by Art Cohn. And
Richard.
can you hear me or no?
One continue and I'll.
Yes, go ahead.
All right. I just want to make a comment. I know that Art had indicated that we shouldn't treat people any differently, and I agree with you. However, that doesn't necessarily mean that punishments cannot be disparate. You know, I've been on the board now for 4 years now, and we've been very, very consistent in terms of cases of abuse against employees and cases of abuse against other members. And while I appreciate the comment that we should treat everybody equally in terms of finding a violation, we clearly took a position, now this board may take a contrary position, that we should make penalties, which we haven't even gotten to yet. You know, we still have to have a motion as to whether there was a violation. But
Yeah, we did that.
We did that already.
We did that. You weren't listening.
okay. Well, I wasn't on the phone. I was listening. I just couldn't get on the video conference. If you go through the series of violations that took place in the past, we always tried to be consistent with section 720.305, which required the board to either levy a fine or impose a suspension if it was reasonable. And as we've discussed on prior occasions, we look at our guidelines, we look at the facts and circumstances of the case, and ultimately conclude what we feel the court may ultimately feel is reasonable based upon positions that we've taken, in the past. Now, if this board wants to take a contrary position, that's fine. But if you go through all of the various scenarios that we had before, and Art had indicated, one such involving an individual who approached someone who touched the hair, who opened up a car. We've had other instances where there was abuse of employees, and we made it a point of increasing the fine and or suspension. Here we have a situation where we had a member that was involved in an incident, which he's acknowledged that he has. For that reason, I thought a suspension was appropriate. Now, as far as the length of the suspension, I felt that a week was appropriate, in part taking into consideration that the Grievance Investigation Committee felt that there shouldn't be any suspension at all. They suggested a $100 fine and a letter of apology, which I didn't think was appropriate under the circumstances. We've had no personal injury here. We've had no bodily injury. We've had no property damage. And I'm assuming that whatever imminent danger that existed at the time of the incident has long passed. So for us to suspend somebody for this particular incident for 3 months, 6 months, I think would be construed by a court as being unreasonable. This board may conclude otherwise, and if they, in fact, vote down the 1 week suspension, let them vote it down, and then let somebody make another motion suggesting that it should be greater. But that's what we've done in the past. If we choose to do something differently, so be it.
All right, Richard, now that you can hear us, there has been a motion to amend the penalty to be for a 1 month suspension, and we are in discussion on that motion now. So, Mr. Goldberg, you were interrupted. Please continue.
Yes. So as I look back at this grievance matrix, I rarely see any suspension that is less than a 2 week period. While Sherman's a pal and Mrs. Grubstein is a member and everybody needs to be treated fairly and equally. Richard commented about damage to vehicles, about threats having long faded. Mrs. Grubstein felt assaulted. at the time of the incident. She felt damaged. She felt frightened. And I believe we need to respect the feelings of the membership and not countenance bad actions. And so I agree that there should be some suspension. I disagree that it should be a month. I would move to amend Mr. Kavanaugh's motion to provide for a 2-week suspension and a $100 fine. And hopefully a letter of apology was approved by Mr. Spina.
All right, there's a new motion to amend, to change the suspension to 2 weeks. Is there a second to that motion? Leo seconds that. Okay, now discussion, Mr. Kavanaugh.
I think the issue, based on Richard's initial analysis and what Mark said, did this woman feel threatened? Bottom line, let's cut all the rest of the crap out. Did she feel threatened? And the answer is, from what I've heard, yes. So therefore, it merits a suspension. Can I accept the 2 weeks? Yeah. I think we have to send a message.
Message?
Any other discussion on this motion? Yes.
I just want to note, which is not in the list of ones we already had, was the recent one we did with the pickleball, the 2 women that there was cursing between them. So I just want to make sure that we get that one in there, because that did have a specific result to that. That wasn't a suspension. So just as we look back, I want to make sure if we're talking about consistency, that we make sure we have all of them there. I don't think that was considered dismissed, but I don't see it in there. So I just want, because we're talking about whether or not they all have and how much suspensions they have. So if we're relying on that, I just want to make sure that they're all listed there.
Ms. Harowitz.
The way I look at this, it seems to me that as the years go on, the board gets rather lenient about suspensions and stuff. Back in 2023, verbal abuse in the grill. That was a month. Violated peace and harmony in the middle of the night. That was 2 weeks and $100. Here we have a woman who was alone in a car, approached by a man she didn't know. He may have worked at Glen Eagles. He may have been a member. He may have been someone who came in to deliver something. I just feel, I think 1 week is too little. I don't think 2 weeks is enough.
Yes, Ms. North.
And Richard actually mentioned there was no bodily injury, but I'm assuming that
Speak up.
Gloria has a lot of emotional and mental, stress over this whole thing. And as a woman, I would, and again, I'm a friend of Sherm's also, but I think this was a really sad situation.
All right. Any other discussion? Understanding what we're discussing now is an amendment to make the suspension be. Okay. So if there's no further discussion, I'll call the question on the amendment for the 2 week suspension.
Was it seconded?
It was seconded. Mrs. Cleo seconded it. So we're going to have to work through this, so bear with me. So with regard to the proposed amendment for 2 weeks, all those in favor of amending the motion to be 2 weeks, please indicate by raising your hand. 1, 2, 3, 4, 5. Motion passes. So the amendment is now to the original motion has been amended to be a 2 week suspension. So that now we have to say for that motion is amended. All those in favor of the amended motion being a $100 fine and a 2 week suspension. That is now the amended motion. All of those in favor of that motion, please indicate. 1, 2, 8. In favor, against, 1. and one recused. Mrs. Harowitz was against and Mr. Wasson. Okay, so that motion passes. Okay. The next item on the agenda is
Good luck, any woman or anybody.
Glen Eagles Country Club versus Patricia Fletcher and Stuart Chadnick grievance.
Jane.
Okay, do you have a motion, Mrs. Feinerman?
Yes, I move that Ms. Patricia Fletcher and Mr. Stuart Chadnick, owners of 15322 Strathern, Unit 11802, at the time in question, each violated Article 20 of the club's amended rules by failing to obtain approval from Palm Beach County to do alterations to their unit, including but not limited to electrical, plumbing, and modification to structure. Additionally, work was done beyond the scope of the DCC application that was approved on September 5th, 2025, which only included mold remediation, painting, flooring, and baseboard installation. While at their unit to close out the DCC application, David, James, Roger, Rich, and Roger Padover observed the additional alterations which were not in scope in the original DCC application or approved by the DCC. To summarize, there are 3 violations that have been committed. 1, starting work without required DCC approval. 2, starting work without PVC permit. And 3, doing work not approved by the Palm Beach County or the DCC.
Is there a second to that motion? Mr. Wasson, does anyone need to recuse themselves from considering this? Okay. Discussion. Mr. Cohen.
This might be the most egregious DCC case that we've seen. And the reason for that.
Can you speak up, please, for the benefit of the honorable?
This might be the most egregious DCC case that we've seen. The reason for that is that this unit was purchased under the second unit purchase program and was purchased under the premise that these folks were buying it to live in it and they were going to sell their first unit. That does not appear to be the case at all. In fact, these people, as I understand it, don't live here. They are pure investors.
Right.
And it appears to me, and I think a fair inference can be drawn, that they could have cared less about violating our rules because suspension means nothing to them. $3,000 fine means nothing to them because it's just coming out of the purchase price. And that to me is really offensive. And I've got more to say when we get to the penalty phase.
Fine.
Yeah, so just so we understand, there's 2 things. So 1, they do own a unit, their first unit, that is rented out. So let's just get the facts out there. That is rented out currently.
Annually.
And it's an annual rental. So I think that's really important that we know that. Also, we did look at the fact that they were, and I don't know if we talk about that separately, but because they were a second unit purchase program, there was discussion around whether or not we allow them to continue to participate in the second unit purchase program. And the discussion is by Florida law, that is not something we can limit them to. That is not within our rights as a board to include in the penalty, because that was up for discussion as to whether or not we exclude them from the program going forward. So just so you know that, having brought that up, that was part of the discussion.
Mr. Cohen.
So what do you think the relevance is? And how do you think it cuts that they rent out the first unit? Does that mitigate or does that exacerbate this fact?
It exacerbates it. So when we can discuss it in the penalty phase, but the penalty is not to them, not just to them personally. We do have the right to have their suspension go to the tenants in their unit. Of any unit that they own, we check the rules on that as well.
Okay, Mr. Cliff.
I have a question. We may not know the answer to this, but did they do the same thing to the first unit? Did they ask for one thing and renovate it completely?
I think, I know that Rich was looking into it. I don't know. Unfortunately, I don't know the answer to it.
That's under review and would be a separate grievance. Potentially that would add on time to whatever units they own, but yeah.
Do it once.
Yep, that is the discussion.
Any other discussion?
Just a comment, in the past, when someone owned 2 units and you suspended them from one, you suspended both.
Oh, absolutely.
Yeah, you know.
Always, okay, yeah.
Yep.
Right. All right, well then I'll call the question. All in favor of the motion? Okay, that's unanimous. Okay, you have another motion now?
Having found that Ms. Flesher and Mr. Chadnick each committed the aforementioned violations, I move that A, Patricia Flesher and Stuart Chadnick be jointly and severally fined $3,000, constituting $1,000 for each violation as there was blatant disregard for the DCC rules, and both be suspended together with any tenant, guest, or invitee of either or both of them from use of all club facilities for 6 months beginning September 1st, 2026.
There's a second on that motion. Carol, discussion. Mr. Cohen.
So the first thing that I think needs to be addressed in that motion is that the suspension
Can you speak up, please?
needs to be made clear that the suspension applies to both units that they own. Right? That's not clear from that language.
It wasn't in that.
So we need to clear up that language. That's my first point. The second point, and just, you're correct, Jen, we don't have the authority in this meeting to impose anything other than a suspension or a fine. But in a recent matter, our council opined that under the current SUP agreement, that second unit sales are not covered. And I think we should be giving serious thought, and I'd ask Craig you to consider this and speak with our council, whether we should be taking the position that when they go to sell the second unit, which I understand is currently under consideration, that we take the position that they owe a new member capital contribution of whatever it is, 95 now or 110.
110.
And that'll make clear that they can't ignore us. So that's something we can't impose, but we have authority from our council to take that position. I think we should give serious thought to that. So I would request that you look into that.
Will do.
I have a question, Greg.
Yes, Mr. Watson.
The lack of permitting and DCC, has that been remedied?
No.
No.
They're
yeah.
supposedly working on it.
Yes.
I just want to say a lot of our suspensions in the past related to DCC was a suspension until you remedy, and that is not, I want to be very clear because that's the discussion we had, there's no remedy that would change this suspension. This doesn't pertain to anything that needs to be fixed and then the suspension is lifted. That's how we've done the DCC in the past. They are suspended, having nothing to do you understand what I'm saying?
No length of, I'm sorry.
There is a length of time, but all of our suspensions with DCC in the past have been a suspension until something has been remedied.
Right.
That is not the way this one's written. This is written as a suspension. Regardless of whether they remedy it in 2 weeks from now, this is a 6-month suspension. I just want to make sure everyone understands that.
So a motion to amend?
Okay. Wait, Mr. Goldberg first, and then you can.
So there is something that needs to be done, and that is to make application to the DCC, have DCC approval, and have Palm Beach County approval, assuming that Palm Beach County has not approved. And I think that the way you might be able to fashion the motion would be that they be suspended for no less than 6 months. But that additionally, in the event that they fail to comply with the DCC in Palm Beach County at the end of 6 months, until such time thereafter, that they comply with the DCC in Palm Beach County. So it could conceivably go for more than 6 months. Are we allowed to do that, Mr. President?
I would say that. Are you making a formal motion?
I'm clarifying for Ms. Feinerman's, and Mr. Cohn's comments. I'll make that a formal motion.
Let's hear it again, Mark.
That the suspension be for no less than 6 months, but that in the event the DCC application and Palm Beach County approval have not been provided, approved, and secured within that 6-month period of time, then the suspension be increased until such time beyond 6 months that the DCC and Palm Beach County approvals have been properly secured.
Is there a second to that motion?
It's too confusing.
Mr. Gatto seconds that motion. Discussion on that motion.
Yeah, I have a question. Yeah, question.
Mr. Lawson, go ahead.
Jen, you said that they're renting the second unit or the first unit out,
Yes. Yes,
and that's the annual?
that's the annual rental of, which the lease ends for that on August 31st. And there's a 95 and a 90-year-old in there, but we feel that if we suspend that starting then we're not, those people actually are very good spenders at the club as well. So we don't want to hurt ourselves just the same. But it's more so that they will have a very difficult time renting that unit again with no use rights. That was the point.
How do you know they don't find out for the same people?
They could, but
No,
it gives them enough time to know.
We ever find out for a fact if they did work on the rented unit?
No, we didn't.
Haven't found out yet. We don't know.
No. Mr. Cohen, did you have any comment?
Yes, I'm just thinking procedurally what the best way, whether we should do one amendment at a time. Deal with Mark's amendment and then get to the issue of the tenants in there. Why don't we do that?
No, I guess I don't understand.
Yeah. So Mark's motion is to insert language to the effect that for a minimum, for a period of not less than 6 months, or for a period of not less than 6 months, and or an additional period of time, such additional period of time as required for them to obtain all approvals, both
Provided they have not been secured within 6 months.
So that's really that's the language that needs to get inserted in B. My amendment is going to be to deal with the tenants.
Right.
If the suggestion, Jen, is maybe more,
It was mine.
give them cover until the end of July, that's fine. Give them notice that
That's right.
on a go-forward basis, those people and no other people are going to be able to use the club. So I can gin up that language.
All right, it's clear.
I don't know if this is the right time, and if not, just tell me. I believe the condo in question is being sold this week. How does that work?
It's not gonna close, I can tell you that.
Right.
Okay, because they said
They'll have no stop, their stop.
there isn't a stop.
Yeah, but not, it needs to be complete and it's not gonna be complete.
Okay,
So
fine.
Okay, so unless there are no other questions, we'll deal with it
Separately, the
sequentially.
renters.
Let's deal with the issue of the proposed amendment that's before us. And that is, as Mr. Goldberg stated, a suspension of at least 6 months and more until such time as the requisite Palm Beach County and DCC requirements are fulfilled. I believe the language you have.
Provided they have not been secured within that 6-month period of time.
So if you really need, Greg,
Yeah.
I'm lost.
Well,
the language would be, the greater or the latter of.
The greater of, right?
The greater of,
It's the greater of, yeah. That's right.
Right.
at least 6 months,
Right.
and it could be more.
Right.
Okay. Are we clear on the motion that's before us? That's to amend the original motion for penalty.
I'll explain it.
Okay. All those, I'll call the question. All in favor?
Just read it so it'll be on, so.
Yeah.
Okay. Can we read it? Read it one more time.
I'm changing the language now, taking Richard's suggestion.
Okay, he'll have it. All right, everyone understand the motion?
Yes. This includes the night.
No, we're just amending the
Okay.
original.
Okay.
We're making an amendment with respect to the suspension. Okay, all those in favor of the amendment, please signify by raising your hand. Okay. Now, Mr. Cohen, I believe you wanted to introduce an additional amendment.
Yeah, I move that the suspension take effect for the tenants of the other unit that they own on August 1st, and that suspension apply to those tenants and any other tenants that may take
The lease goes till the end of August.
at the end of September 1st then. Because maybe they'll swap them out. Maybe they'll leave now so they can't bring somebody new in. So if we have to chin up the language, we can do it today.
Well, I mean, we need it for the motion. So
Yeah, so I move that the suspension be applicable to the other unit owned directly or indirectly by these people. And to any new tenants, it's too hard, Greg. You need to type it out. I can't do it off the top of my head.
While we're waiting, can I ask the questions?
Is the sale of this unit going through a realtor that is in-house, and should realtor be aware of the situation where they are? Okay. Okay.
This motion only speaks to the second unit.
It's, originally we had,
Mrs. Fineman.
sorry, if I'm going to speak, I guess I should raise my hand. So originally we had in there any unit that they own, but I think we just put, because it's them, it's their tenants, we didn't think it had to speak specific to their unit. To the Strathern unit, it was any unit that they own. That is what our rights are. That, and like Craig said, it applies to the people and any units that they own, and not specific to the unit. That's all.
And that was the motion that I amended, correct?
Yeah. Yes. Yeah.
With respect to the second motion, I believe it's fair to say that any suspension related to the present and or future tenants of the second unit shall be effective only commencing September 1, 2026, and to be coextensive with the period thereafter of the suspension as set forth
Correct.
in the prior motion. Does that make sense?
Yeah, they could swap out tenants now. People there to leave now. We don't want to bring somebody new.
To the existing tenant and any subsequent tenant. Can the reporter read that back, please?
Z, do you have an Advil?
You want to come back?
No, I think I would like to close this.
We have to publish. Yeah, we have to.
We're dealing with language here that, we've got the motion to amend the suspension with respect to the tenants.
Just up to the period of grades of 6 months.
I have to come back to that language.
Yeah.
That
Well,
language is-
we've passed the first amendment.
Yeah.
correct?
For the.
Yeah.
So the second amendment is that the foregoing suspension as it relates to the existing or any other tenant of the unit become effective on the 1st of September, 2026, and to end coextensively with the suspended period as set forth in the prior motion.
What did he say?
I don't know what that means.
I think we made it very.
They lost me. This meeting is called to order.
I think you made it very complicated and really simple.
So, traditionally, as we've looked at DCC, a suspension for violating the DCC process, I think, is in its own. Once a violation under DCC has been cured, not because you violated the rule, but once it's been cured, you go to the county permits are approved, and your CO is issued. Just looking online, it looks like it's very difficult to keep the suspension going. So suspend until it's cured. And then the violation of the DCC rule itself, I think, should rest on its own. And if it's 6 months, it's 6 months.
That was my point.
The unit just did not close today. And what Kristen said was that it's contingent upon the violation being cured and 5 days after that. So, and they failed their 3 inspections. Just no kidding.
Sorry, I just think we're amending this, yet nothing personal, but I feel like I'm not sure they're going to let this go longer than where it's a couple months out and then another 6 months. It's not going to go longer than 9 months until they get this all until they get this all done and sell it. So we're sort of amending it, assuming it's going to take them longer to 6 months to do that, which they're not going to allow to happen because they have buyers and they're already most of the way through the process if they're already at inspections. So I don't know if, well, you said they failed 3 inspections. So they're at least at the point where things are getting inspected. That being said, I don't think it's going to be 9 months till that was just my point. We're sort of amending it to
be in 9 months.
Remediation
Really?
if it's greater than 6 months. You understand what I'm saying?
I do.
Okay, thank you.
Yeah, no, that makes sense.
They want to be out of here already.
They want to be out of here already. What do you think, Art?
No. The new member capital contribution.
That's a whole different.
That's what I want.
I'm with
I want to hold it there.
We don't want to return them the second. I don't know if we can't take a whole lot.
We'll negotiate it.
Additional time.
You ready?
Which is what's before.
Okay.
So, we've got the original motion that's been amended by Mr. Goldberg's amendment, which the question that we're debating, as I understand it here, is concerns the tenants in the other unit, right? And when that begins. Now, the original motion stated that that suspension would not begin until September 1st, to give the expiry of the existing tenant's lease on August 31st. So I guess my question is, we're struggling about what language, if any, we want to have with respect to those tenants and any future tenants. And I would argue that I'm not sure we need to amend the motion any further. Now, I put it to you, is that if someone feels strongly.
Well, what if they renew their current lease with those folks for another year?
But the suspension going to start on September 1st.
Yeah.
They're going to know going in that they have the no use rights for 6 months.
At least, right? Well, then then we have to have language that makes that clear. I mean, that's fine, Greg. Why do you think that that's clear from the current language?
You didn't say in any tenant, and that the suspension starts.
I don't think it's, we need to make the person aware of it, regardless of whether they lease it out. Our rule is you can't lease it out. That's their problem. We need to get to the lessee and say, hey, listen, just want to make sure. I would be very disappointed if the owner didn't say, hey, guess what? You're not going to have club use rights, and they're going to darn sure know it. And trust me, that new lease has got to come to us. I'm sure it'll make its way back to the lessee that, hey, did you know? I'll make sure it does. So I wouldn't worry about that at this point. They can't lease without coming to the club and without going to the association again with a new lease. So we can be there to protect that one.
Is there any further discussion on the original motion as amended by Mr. Goldberg's amendment, which was passed? That's 6 months plus any additional time to comply with the necessary requirement.
Did that include the $3,000?
Yes, we haven't changed the financial.
Okay, that's what I asked.
I guess they're debating whether they want to further.
I'm going to show you the language in a minute. You can tell me what you think.
Are you going to propose a further amendment?
I'm going to propose a further amendment, Mr. Benson.
Okay.
All right. Amended language, having found that the entire amendment, the entire motion, not just
Okay.
the
This is your proposed amendment.
proposed amended motion. You get the point. Having found that Ms. Fletcher and Nick each committed the aforementioned violations, I move that A, Patricia Fletcher and Stuart Chadnick, A, be jointly and severally fined $3,000, constituting $1,000 fine for each violation as there was blatant disregard for the DCC rules, and both suspended together with any guest or invitee of either or both of them from use of all club facilities for a period of the greater of 6 months or until all approvals, including DCC and Palm Beach County, are obtained. C, this suspension shall apply to both units owned directly or indirectly by Mrs. Fletcher and Mr. Chadnick, and any tenants except the current tenants of Glendevin Lane may continue to utilize GECC until 8/31/2026.
Okay, is there a second, Mr. Wasserman? Is there any discussion? Mr. Fletcher. Oh, that wasn't a discussion. Mr. Feldman, you okay? No discussion?
I'm not going near it.
Used up your words for the day.
So,
Other words.
all right, there's a second on this amendment to the original motion. So all in favor of the amendment to that original motion? Indicate by yes. Okay, so that's the amendment. So the original motion as amended. All in favor? Yes, my God. Man,
The easy one today. Just saying. We gotta send it.
When does that suspension start?
Okay. I thank you for your diligent work on that. Mrs. Cleos, unfortunately, we have a couple of financial suspensions on the agenda, item M, so
The first one is, I move to suspend the members resident at 15783 Loch Marie Lane, unit number 5106, Delray Beach, Florida, 33446, together with any tenant, guest, or invitee of these members due to financial non-compliance. Said suspension also to include suspension of these members' voting rights pursuant to Florida statute 720.305, parens 4.
second on that, Mr. Pato, discussion? All the question, all in favor? It's unanimous. You have another one, unfortunately.
Unfortunately. I move to suspend the member resident at 15799 Loch Marie Lane, unit number 5303, Delray Beach, Florida, 33446, together with any tenant, guest, or invitee of this member due to financial non-compliance. Said suspension also to include suspension of this member's voting rights pursuant to Florida statute 720.305, parens 4.
Second, Mr. Pat over again. Discussion? All the question, all in favor? Okay, that's unanimous as well. You've been presented with the citations for the last month. Mr. Goldberg, I believe you have a motion.
Yes, I do. I move that the traffic citations given to the individuals listed in the notice of today's board meeting are in order and are approved, and the fines or warnings for those citations as set forth in the established recommended penalty guidelines or infractions are approved.
Second, Ms. Moss. Discussion? Okay, all in favor? Passes unanimously. Committee reports. Are there any questions with respect to any of the filed committee reports this month? Good. Good and welfare. Any good and welfare for us today? Mr. Goldberg.
I just want to once again thank Craig and his staff and the entire leadership team for all of the incredibly hard and attentive work that's been put forward in connection with this renovation. I know we're all going to be thrilled when it's completed and anguished while it's ongoing.
Got a lot of work.
But kudos and wonderful work there. Thank you.
Any other good and welfare?
Here we go.
Well, the next board meeting is,
June 25th.
somewhere here.
June 25th.
June 25th. And, having no further business, we are adjourned.
All right.
Oy.
What's today, Thursday?